Hello everyone. In this two-part video series, I'll be talking about the new IT rules that have been introduced, which are formally known as the Information Technology, Intermediary Guidelines and Digital Media Ethics Code Rules 2021. So the path of this two-part video series will basically be the first part, talking about how exactly these laws came into place, what exactly led to the creation of these laws, and how are companies complying to these laws. The second part will be a comparison of the Indian laws and how UK is regulating, if not actually regulating, their online services and digital media. So let's start with the first part. So what exactly led to this whole creation of these laws? So I'll be talking about the Prajwala case 2015 here. So Prajwala, an NGO based in Hyderabad, wrote a letter to the Chief Justice of India, which was then, as you can see on your screen, Handyala Lakshmi Narayana Swamy Dattu, and this was on the 18th of Feb 2015. Now, he then handed over this letter to the Supreme Court, and on reading, the Supreme Court of India took up the matter, which it called of great public interest, and initiated a hearing on its own. I will not be talking about the contents of the case here, but I request you to take some time off your schedule, and if you are mentally well, because this case is pretty brutal to read, please go through it, as the case is really sad to read, as I said earlier, as it talks about the things, the sick and the shitty people in our society can do. There are also 6 suggestions that are made by Prajwala in this case, which are very interesting to read according to me, and talk about how we can stop such technology-driven sexual crimes. The link to all the case documents and the timeline is given in the description of this video. So if you're interested, definitely go through it. Fast forward to 2018, the Government of India informed the Supreme Court of India of the actions it undertook to stop technology-driven sexual crimes. And in those actions, it mentioned of some actions that are to be taken by the intermediaries as well, which were setting up proactive monitoring tools, deployment of trusted flaggers, setting up of 24/7 mechanism for dealing with requisitions of law enforcement agencies, appointment of Indian-based contact officer and escalation officers with name, designation, email, and phone number. A prompt disposal of requisition of law enforcement agencies to remove these, unlawful contents. And aid to the code also suggested that the monitoring and deployment of keywords will also be needed to considered by these intermediaries. The court later asked all the parties, which included Facebook, Google, Microsoft, WhatsApp, Yahoo, and the Government of India, to come up with a plan on implementing the suggestions that were provided by the government earlier. Where we see that couple symbol appearing for WhatsApp tells the Supreme Court of India that they have an end-to-end encryption technology, due to which it will not be possible to remove the contents. On the 16th of December the same year, the court asks the Government of India to come up with a set of guidelines to eliminate child pornography, rape, and gang rape imageries, videos, and sites in content hosting platforms and other applications. The Government of India then releases a draft on the new IT rules on the 25th December, link for which can be found in the description. Now, I won't be discussing all the points here, but some of the significant ones that were present in the draft, which were: the intermediary shall publish the rules and regulations that inform the users not to host, display, upload, modify, publish, transmit, update, or share any information that A, belongs to another person and to which person the user does not have any right to. Second point being, is grossly harmful, harassing, blasphemous, defamatory, obscene, or otherwise unlawful in any manner whatever. The third point being that, if it harms minors in any way. Fourth point being, infringes any patent, trademark, copyright, or other proprietary rights. Fifth point being, violates any law for the time being enforced, deceives or misleads the addressee about the origin of such messages, or communicates any information which is grossly offensive or menacing in nature, impersonates another person, contains software viruses or any other computer code, files, or programs designed to interrupt, destroy, or limit the functionality of any computer resource. threatens the unity, integrity, defense, security, or sovereignty of India, friendly relations with foreign states, or public order, or causes incitement to the commission of any cognizable offense, or prevents investigation of any offense, or is insulting, to any other nation as such. And the last point being that if it threatens the public health or safety, promotion of cigarettes or any tobacco products, or consumption of intoxicant, including alcohol and electronic nicotine delivery system, which is basically a vape devices, and like products that enable nicotine delivery except for the purpose and in the manner and to the extent as may be approved under the Drugs and Cosmetics Act 1940 and rules made thereunder. And of course, threatens the critical information infrastructure. Now, when required, it also said that, when required by the lawful order, the intermediary shall, within 72 hours of communication, provide such information or assistance as asked for any government agency or assistance concerning security of the state or cyber security. The intermediaries who have more than 50 lakh users in India or, is in the list of intermediaries specially notified by the Government of India shall have a nodal person of contact and alternate senior designated functionary for 24/7 coordination with law enforcement agencies and officers to ensure compliance to their orders are made in accordance with the provisions of law or rules. The intermediary, upon receiving actual knowledge in the form of a court order or being notified by the appropriate government or its agency, shall remove or disable access to the unlawful acts such as which are in the interest of the sovereignty and integrity of India, the security of the state, as mentioned before, the friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offense on its computer resource without vitiating in the defense in any manner. Basically, not infringing or not disturbing the evidence at all, not changing anything to it. As far as possible, immediately, like they should be sending this to the state immediately. And it should not be, later than 24 hours. Further, the intermediary shall preserve such information and associated records for at least 180 days for investigation purposes or for such longer period as may be required by the court or by government agencies who are lawfully authorized to do so. Now let's actually hit to the period when the rules were actually introduced, which was basically the Feb of this year first. Now, when the GOI Government of India, came forward with these rules, which were framed in exercise of powers under Section 87(2) of the Information Technology Act 2000. The rules document states the following as well. Now, this is the government saying this. It was found that currently there is no robust complaint mechanism wherein the ordinary users of social media and OTT platforms can register their complaint and get it redressed within defined timeline. So now there are certain rules which are applicable to both social media platforms and digital media, which includes the news and OTT platforms, and some which are just specific to the social media platforms. So first, what are these rules actually called? They go by, as I said earlier, just to remind you, Information Technology Intermediary Guidelines and Digital Ethics Code Rules 2021. Thus making it clear that, they're applied to the digital media and the intermediaries that we have been talking about, which is basically Facebook, Google, Twitter, WhatsApp, Instagram, etc. So there are two parts to this. The guidelines related to the social media companies will be administered by the Ministry of Electronics and Information and Technology, and the guidelines for the digital media will be administered by the Ministry of Information and Broadcasting. So let's get over the guidelines which are applicable to both set of intermediaries. First being due diligence, which basically refers to taking reasonable and logical steps only, and if not, then basically whatever the people say on your platform, the platform will be held responsible for it, which is no safe harbor. Second point being the redressal mechanism, establishing a grievance redressal mechanism for receiving resolving all these complaints from the users or victims. Intermediaries shall appoint a grievance officer to deal with such complaints and share the name and contact details of such officer. The grievance officer shall acknowledge the complaint within 24 hours and resolve it within 15 days from. The third point being online safety. So the intermediary is required to remove or disable access within 24 hours of receiving of the complaints of contents that expose the private areas of individuals, which show such individuals in full or partial nudity or in sexual act, or is in the nature of impersonation, including morphed images, etc. as well. Such a complaint can be filed either by the individual or by any other person on his or her behalf, thus addressing online safety and dignity of users, especially the women users. Fourth point being content removal. Now, an intermediary, upon receiving actual knowledge in the form of an order by a court or being notified by the appropriate government or its agencies through authorized officer, that is, should not host or publish any information which is prohibited under any law in relation to the interest of sovereignty and integrity of India, public order, friendly relations, with other foreign countries as well. Now, let's look at some of the rules which are specific to the social media intermediaries. As stated in the draft, there will be two categories. One with below 50 lakh users and other with above. And they will be called as significant social media intermediary. And they will be additionally required to appoint a chief nodal officer who shall be responsible for ensuring compliance with the Act and the rules. Then a nodal contact person for 24/7 coordination with the law enforcement agencies. And then a resident grievance officer who shall perform the functions mentioned under the grievance redressal mechanism. And of course, they should all be Indian citizens. They will be required to publish a monthly compliance report mentioning the details of complaints received and actions taken on the complaints, as well as details of contents removed proactively by the significant social media intermediary. They shall enable identification of the first originator of the information that is required only for the purposes of prevention, detection, investigation, prosecution, or punishment of an offense related to, again, the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, or public order, or incitement to an offense relating to the above or in relation with, as I stated earlier, rape, sexually explicit material, or child sexual abuse material, which will be punishable with imprisonment for a term of not less than 5 years. Intermediary shall not be required to disclose the contents of any message or any other information to the first originator. Significant social media intermediary shall have a physical contact address in India published on its website or mobile app, or both. Now, there are two more things that the bill basically talks about. First being the voluntary user verification mechanism. Now, the users who wish to verify their accounts voluntarily shall be provided with an appropriate mechanism to verify their accounts and provided with demonstrable and visible mark of verification. Now, this is something that we see even Vietnam recently encouraging its citizens to actually input their as such real IDs on the internet. And the example for this kind of thing could be the verified mark that you get on Instagram and Twitter, even on Facebook as well. So that verifies, this very celebrity's account is actually this very celebrity, talking or tweeting or talking to the people. It's not some fake account. So this will be applicable to people, not famous people as well, people like us. Second is giving users an opportunity to be heard. In cases where significant social media intermediaries remove or disables access to any information on their account, then a prior information for the same shall be communicated to the user who has shared that information with the notice explaining the grounds and reasons for such action. And the users must be provided with an adequate and reasonable opportunity to dispute the action taken by the intermediary. Now we will look at the guidelines which are specific to the digital media. Here, before I discuss the guidelines, I wanted to talk about the reasons that the government gave for the below as well. Because this wasn't something very keenly discussed in the draft as well as in the Prajwala case, but actually got attention in Rajya Sabha when members expressed concern over social media platforms spreading fake news. The government of India says that there were widespread concern about issues related to digital contents both on digital media and OTT platforms. Civil society, filmmakers, political leaders, including the chief ministers, trade organizations, and associations have all voiced their concerns and highlighted the imperative need for an appropriate institutional mechanism. The government also received many complaints from civil society and parents requesting interventions. There were many court hearings in the Supreme Court and High Courts where courts also urged the government to take suitable measures. Now let's jump on to the guidelines part. Here we see that the government has allowed the digital media intermediaries, which includes the OTT platforms as well, to have a system of self-classification of content. Self-classifying the content into 5 age-based categories, which namely being U, that's universal, U/A for 7 plus, U/A 13 plus, U/A 16 plus, and A being the adult version. Platforms would be required to implement parental locks for content classified as U/A 13 plus or higher, and reliable age verification mechanisms for content classified as A, that is adult. The publisher of the online curated content shall prominently display the classification rating specific to each content or program, together with the content discretion informing the user about the nature of the content and advising on viewer discretion at the very beginning, if applicable, at the very beginning of every program, enabling the user to make an informed decision prior to actually watching the program. Now jumping on to the publishers of news on digital media, they would be required to observe norms of journalistic conduct of the Press Council of India and the program code under the Cable Television Networks Regulation Act, which are the same rules that are followed by the newspapers as a print medium and television medium. Now coming to the main point, which has received some harsh reaction from the media outlets, is the 3-level grievance redressal mechanism, which is basically divided into 3 levels. That's level 1 is the self-regulation by the publishers. So publishers shall appoint a grievance redressal officer, as I had stated earlier, based in India, who shall be responsible for the redressal of the grievances received by it. The officer shall take decision on every grievance received by it within 15 days. Coming on to level 2, self-regulation by the self-regulating bodies of the publishers. So there may be one or more self-regulatory bodies of publishers. Such a body shall be headed by a retired judge of the Supreme Court, a High Court, or independent eminent person, and have not more than 6 members. Such a body will have to register with the Ministry of Information and Broadcasting. This body will oversee the adherence by the publisher to the codes of ethics and address the grievances that have not been resolved by the publisher within 15 days. Now going on to the level 3, this is actually an oversight mechanism. So the Ministry of Information and Broadcasting shall formulate an oversight mechanism. It shall publish a charter for self-regulating bodies, including codes of practices. It shall establish an interdepartmental committee for hearing all these grievances. Also, the Secretary of Ministry of Information and Broadcasting will have emergency powers to take down any content. But as I had said before, the media didn't like the last part, as the government in the rules document states, over the years, the increasing instances of misuse of social media by criminals, anti-national elements have brought new challenges for law enforcement agencies. Now, I'm not going to give my opinion on anything here, as I just wish to explain the facts, but I would recommend you to read this very interesting opinion piece by The Hindu, which raises some questions regarding the rules, the link to which I have given below. It might be an article though, so, a paid article basically, so if you know anyone of your kith or kin with a subscription, just go and read that article then. Also, you must have seen that WhatsApp put a case against the government of India. If you want to read about the confusing mess that thing actually is, I put the link to a nice explainer article by the Indian Express in the description, because it's a very big confusing mess. Again, that's why I'm not explaining it here. And again, with Twitter recently, losing safe harbor, which I had explained when talking about the laws, what exactly the safe harbor is. A parliamentary committee headed by Sashi Tharoor, during its discussion with Twitter on the misuse of its guidelines and the misuse of its platform, told them that the law of the land is supreme and asked them to abide by them. Because earlier, Twitter had said that they are making every effort to comply, as they kept delaying with the appointment of the chief compliance officer. Also, you must have seen that recently UN wrote to the government of India on the new IT rules, and in brief, they said that the new IT rules are in violation of the rules laid down in the International Covenant on Civil and Political Rights, that's the ICCPR, which is a key international human rights treaty. And they said that pursuant to Article 19.3 of the ICCPR, restrictions on the right to freedom of expression must be expressly prescribed by law and necessary for respect of the rights of reputation of others, or for the protection of national security, or for public order, or of public health or morals. This is what exactly in short, I'm telling what the letter stated. Basically, they were like, the definitions under the new IT rules are too broad and can actually be misused. To which the government of India were like, concerns, alleging the potential implications for freedom of expression that the new IT rules will entail is actually highly misplaced. So now we see that the government is actually trying to get other companies to comply with them. And soon enough, I'm guessing they will be successful with it as well. So this ends the part 1 of this video. In the part 2, as I said, I'll be talking about UK. In the document that the government has released regarding the new IT rules that were released, the government states that while making these guidelines for digital media intermediaries, they looked at models in other countries also. And the countries they listed were Singapore, Australia, EU, that's the European Union, and UK, United Kingdom. So I decided to actually compare this with the existing and to be applied rules in any one of the countries stated above. And so I decided actually I should go with the UK. And why exactly the UK? That I'll be talking in the next part of this 2 video series. So I hope you come for the next part as well. That's it for this part. Thank you so much.